Clause 37 exists, and the court will take judicial notice that in the charge sheet fall squarely on a date that Article 37 was applicable. And that being the case, the drafters of Porter would have stopped Section 2B and not included the proviso that, I will read it for the court as it retires, provided that an act which disrupts any services and is committed in the pursuance of a protest. In fact, Porter does not use the description of the. It foresees that such protest may not be peaceful. So that, as we have seen, allegedly there was property that was destroyed or damaged, and it continues to say, demonstration or stoppage of work shall be deemed not to be a terrorist act within the meaning of the definition, so long as the act is not intended to result in any harm referred to in A1 to 4, which is the present case. On that date, materially, the court should take judicial notice that there was a countrywide demonstration pursuant to Article 37. As the court is winding up and retiring, Your Honor, we all come from different backgrounds and we all have things we do in life. I was once told by my grandmother that even a motive, for instance, those who work in mortuaries or places or funeral homes may picket and demonstrate when their workload goes down. What I mean is that when the mortality rate of Kenyans go down, Kenyans are not dying. Morticians may complain. The work of the Director of Public Prosecution is not an easy one. It is akin to that of a mortician. And there are our colleagues on that side. And I any person who was urged will not talk much about it because we are being led by senior counsel and he's my friend. It was meant to be a joke, but everyone here is serious. Today, the persons before this court, the persons who are intended to be charged, but tomorrow, they may be our heroes. I urge this court as it retires with the utmost humility, because now, unlike the EPP, I mean it. Count number 1, because we will come to discuss The other counts, as I had said on the question of jurisdiction, it is our position that on the second count and the third count, jurisdiction to deal with this matter under the CPC as Section 71. So these alleged offences were not committed within the precincts. Other courts which can deal. I know the BPP is itching to say that the Kikuyu court is not functioning. But there is another court nearby which can handle.
Referred to by Mr. Mwangi. Mr. Mwangi wants to convince you that there are two parts of that proviso that can occasionally deemed not be terrorists act within the meaning of the definite of the referred to in paragraph A, Roman 1 and Roman 4. Roman 4 is what is of our interest. He tells you that this should be the act of protest, demonstration, or stoppage of work. That is the act which the proviso is. Is not to the banning, destruction, or anything. It's to the action that has originated. Why am I on the street? To demonstrate. I urge you to rely on the golden rule of statute interpretation. It will not lead you to arriving to the absurdity and the mischief being actuated and perpetrated by the ODPP. The golden rule into, if applied, Your Honor, will lead you into resulting into the golden rule, when it's used for interpretation, would lead you to arriving at a decision that looks at the purpose of the legislation, the mischief the Parliament wanted to address. Finally, the golden rule allows you to depart from the literal meaning of a statute when such an interpretation would lead to unreasonable or nonsensical results, to which the DPP is inviting you to. I rest my case.
Yes, you know, say for the strong words by counsel, especially the Wanjiru here, about nonsensical stuff. I want to respond to that because I know that, decision to charge is a very solemn decision. It carries a lot of repercussions. And we have taken the decision bearing in mind the responsibility that we have, and especially also bearing in mind the current circumstances that we are all as Kenyans are undergoing. And before I sit down, I just wish to say that there is a lot of this understanding on the import of the exemption.
Where is he coming from? I don't think he has audience, Your Honor, with due respect, and we wish to object to that because we are now reopening the case. Counsel cannot submit on anything that he has not submitted on. Unfortunately, that is the rule, and the court must be bound by those rules. We can't make our own rules. Yes.
Your Honor, yes, I understand, Your Honor.
Because you remember I gave directions when Mr. Kamau was on the street. I understand as much. And when Mr. Mashira was on the street, I said to him, reserve anything that you want to say. And I'm not opening up for the prosecution to make any new submission, but simply to say on this point, this is what I was objecting to at the point.
No, yes.
And to leave it there.
You know, I am well guided, but I still insist that unless the court wants to make its own rules that governs proceedings, that this gentleman, the DPP, has no audience before you. And I would wish you to make a ruling on that, Your Honor. I make an application that you make a ruling on that.
Your tremendous respect, the law society is here and you represent Mr. Ndego and we are asking him and advising him to proceed.
I'm well guided here.
Yes, Your Honor. Yes, and thank you to yes, thank you to the Deputy President of the NSK.
But Your Honor, until when shall we be intimidated by the NSK? We advocate for our own rights.
Just to save time, the Deputy President NSK went into the realm of new matters. And therefore, once you go to the realm of new matters, it gives a realm for the DPP to address. But I'm not going to address anything. Just a sentiment. The DPP, and that is what I was saying before I was told to sit down, was acting on its official mandate to do what we have done. And we are saying that we are going to disclose all this evidence that we are comfortable, that it is within the law and nothing nonsensical that we are doing. So kindly, we treat each other with a lot of professional courtesy. This is not between us, it's not between you. The matter only affects these people that are before this court. And let us not personalize. Thank you.
It doesn't need.
It will not be allowed, Your Honor.
Only that, Your Honor.
There should be a sergeant at arms.
Yes.
Your Honor, I want to make a proposal in regard to Ms. Figure and Peter. Because we will be making the same application, if we can simply proceed with those two will be called, such that when you go to make a ruling in regard to all three items, because we will not be taking any fees before the same.
Indeed, I think even for the time.
And in those two, we will mostly be adopted.
We are in agreement, Your Honor.
Criminal case number 70. Criminal number 70, 2025. State versus Peter Kinyanjui, alias Wanjiro, Sarah Wanjiko.
They should be here.
Peter and Sarah.
council, I'll be raising high constitutional questions, 5 of them, objecting to the judges. Only constitutional questions, because the council have already raised the issues. My name is Odieki. Yes. I've raised 6 constitutional questions, which I want you to address when you retire. This is a fresh matter, yeah.
We are taking quorum.
Okay.
I think that is a procedural
Yona, in the matter, Mashira appearing for the state, alongside Mr. Kamau, Kevin Kamau, and Joyce Wangui, and also Mr. Kennedy Amwai. The defense may introduce themselves.
Your Honor, quorum for the defense remains the same. Additionally, I beg your pardon, Your Honor. In addition to the defense team, we have Counsel Ismail Goringa. Goringa?
I'm here, Your Honor.
I think you're from Thika, right?
Yes.
Yes. And Counsel Wariuki Jiri. Thank you, Counsel.
Mr. Njiri is the new council that's coming in. Mr. Nguyen.
Yes.
Where is that? Yes, Your Honor. We raise the same objection with regard to count 1, account of terrorism against these 2 officials. I need to mention they are actually even party officials, and there's an element of serious persecution. The officials of the DCP, Democracy for Citizens Party. They are the officials of a party, which is a party in coalition with several others, including those represented by Council Eugene Wamalo and myself. The party leader is the Honorable Gachagua Brigadi. It is important to take that into consideration, that you are seeing state high-handedness. Whenever they hear the name Rigathi Gachagua. So, Your Honor, I'm going to invite Counsel Kibe Ngai to highlight the circumstances that befell these 2. It is what I was referring to, partly, as literally weaponizing the Prevention of Terrorism Act. That anybody the state feels is not towing their end of political line, is haunted and charged with terrorism. Being officials of a party
no party would want to have in their midst terrorists. Therefore, we strongly object to this count. And I therefore want to invite Wakili, because these two were even admitted to bail in an earlier court. And in order to further the concept of persecution, they are to be rearrested as if they were Al-Qaeda criminals or Al-Shabaab and hunted to prison, I mean to police custody. Mr. Kibben.
Thank you, Your Honor. I rise from the outset by indicating the fact that we adopt all the submissions that have been made by my learned colleagues in this matter with regard to the earlier file. So what we shall be submitting all is try to make some necessary elaboration to supplement and to complement the submissions that have already been made. Your Honor, apart from taking off from the point that has been made by Senior Counsel Kalonzo Musyoka about this accused person, Your Honor, there is an important background that requires to be made that touches on the validity of the charges that are before this court. And that issue Your Honor, is that on the 4th of July this year, in two separate rulings, number one, in Kiambu miscellaneous criminal application number 279 of 2025, number miscellaneous 290 E290 of 2025, Republic versus Kelvin Gakunyi Nyavera and two others. The second respondent, one of the Sarah Wanjiko Vega was the second respondent. And she was a subject of a ruling that was issued on that 4th of July 2025 by the Honorable Mr. Honorable Gevi Kibiru, the Chief Magistrate of Kiambu. And the basis of the ruling was with regard to an application by the GPP seeking to oppose bond in order to secure further detention of Ms. Wajiko Vega. There was also on the same day a ruling before the Chief Magistrate's Court at Roiro in relation to Peter Kenyanjui Wanjiro, read on the same day, and where the DPP had made a similar application. That case in Roiro is criminal, miscellaneous criminal case number E465 of 2025. We shall make arrangements to furnish this court and the prosecution, if they do not have already, the said two rulings. In those two rulings, Your Honor, the summary basically is this. The offenses, particularly the particulars of the offenses, facing those two accused persons are exactly the offenses that has precipitated their arraignment before this court. You're in both those two rulings. Your honorable honored colleagues, the chief magistrates, ruled that the prosecution had not tendered the required evidence or grounds to justify their further detention. Your Honor, those two rulings under the jurisdictions of our country are appealable to the High Court by law at the instance of the prosecution. But, Your Honor, the prosecution, because it is part of the executive under the Constitution, they appear under the executive chapter, only that it is supposed to be dependent. They chose, instead of complying with the orders made by your honorable colleagues, they decided to deploy the anti-terrorism officers, ATPU, to invade the hallowed precincts of the court, and for all practical purposes, abduct those two accused persons for purposes of the current arraignment that is before you. Your Honor, it is unfortunate that yesterday we were unable to access our office, but since Friday, after they were abducted at Roiro and Kiambu law courts, I had an intention to bring an important authority from the House of Lords, known as Bennett versus Horse Ferry Road's Magistrate, a decision from England. Bennett versus Horse Ferry Road's Magistrate, I can't remember the other citation. But it is one of the most important decisions that could be applicable to what is happening here today. I can't remember the citation. I remember the name of the case. Bennett, B-E-N-N-E-T, versus Horsferry Roads Magistrates Court. Chief Magistrates Courts like you. We shall furnish that decision as soon as we are able. Your Honor, in that decision, the basic issue was this, that Bennett had been, was somewhere in South Africa. South Africa and the United Kingdom had extraditionary arrangement where you could extradite a person to England. You know, but without getting Bennett from South Africa, pursuant to the extradition treaty, they decided to do a BCG, basically to get Bennett from South Africa, get him to England, and charge him. Bennett challenged his prosecution on the ground that there could be and there cannot be lawful criminal proceedings pursuant to an unlawful and unconstitutional act. There can be no, there is absolutely no validity. In the ultimate, the House of Lords allowed the objection of Bennett, one of the best decisions one can read, and basically saying that, my senior counsel can read the citation.
Yes, indeed, Your Honor. It's Bennett versus Horseferry. Horse as in horse. Disappeared.
Horseferry. You can read the one.
Sorry.
Your Honor, some of these passwords are for the family.
Indeed. Even worse.
Just read if you
Celebrate technology, Your Honor, but
Then it was his
yeah,
horse
please
ferry
do.
magistrates and another.
Horse as in
Ferry is
horse.
like horse and ferry,
Yeah.
magistrates court and another.
the
That's in
citation.
1993 All England reports at page 138 and 151 House of Lords.
Yes, my lord. So that, Your Honor, the basic finding by the House of Lords in allowing the motion was that this prosecution had to be prohibited, not because the state had no evidence, and not because the prosecution did not have sufficient public interest to charge Mr. Bennett, but it needed to be stopped. Because once the prosecution and the police in England engaged in unlawful conduct and unlawfully arraigned the accused person, the court would be aiding and abetting an illegality. And the violations of the rights of the accused persons, in terms of the protection of law, if such a prosecution were permitted to proceed. Accordingly, Bennett was discharged, not acquitted, in order to give the prosecution a chance. To arraign him to court in accordance with the law. And so that the court's hands are not stained with the blood and the illegalities, like the acts of abduction and violence that was witnessed at Roiro. Your Honor, applied to this particular case, the issue is simple. The accused persons, once an order has been made, and it used to be civilized a long time ago, once an order has been made that a person has been admitted to bail, it must mean at the very minimum that that person must spend a night in their home, in their house. Otherwise, it would mean that the only choice that the magistrates at Roiro and Kiambu had was to agree with the prosecution. And if you disagree with the prosecution, we abduct within the same courts and bring somebody to committee. Is it called Kahawa or committee? This court?
It's Kahawa.
Kahawa.
Anti-terrorism.
And bring somebody to anti-terrorism court.
But the nature of the confinement, you are right to call it committee.
It's okay. So that
Your Honor,
Yes.
I'm going to claim counsel.
he will add anything after me, so he will not speak for now. So that, Your Honor, the issue, and it should bother the conscience of this court, because what's the image that the prosecution and the police, anti-terrorism police, are projecting? That those people that we cannot prosecute on a low threshold of law, we take them to Kahawa law courts, the anti-terrorism law courts, on the same issues, on the same charges, on the same facts. Yes. Yes. My Lord, if that were to be the case and were to be permitted, it would mean that the critical gain under the 2010 Constitution in terms of ensuring that the courts are not an executive branch and an extension of the executive arm of government would have come back. The courts in Roiro and Kiambu did act independently. And so the accused person asked me one thing. Why is the state confident that monkey business that is not possible at Roiro and Kiambu is possible before the Kahawa law courts? You know, we beseech you to make it very clear by allowing our objections, by saying that Kahawa law courts is also part of the Kenyan judiciary and will do its duty to protect the fundamental rights of Kenyans. Your Honor, my learned colleague, Senior Wamalwa, is showing to me the fact that the Judicial Service Commission actually issued a statement to condemn and object to the actions of the state and its officers that has precipitated the appearance of the accused persons before you. So that, Your Honor, from these facts, it is quite evident that the accused persons, they are armed with orders of the court, setting them free until the state has put its house in order with regard to the same facts that are before this court. Two immediate things arise. Number one, the only way to uphold the dignity and the authority of the judiciary and the courts must be by ensuring that once orders have been given, particularly against a specific group, the DPP and the police, those orders must be complied with. And a contrary action cannot be countenanced before there is full compliance. And it is easy what that compliance is. They needed to walk out of those police stations or where they were being remanded and to go and spend at least a night at their homes, at their respective homes. That is at the very basic minimum what it required. Arising from that, number two, Your Honor, is that there is an obvious contempt of the court. Contempt of the court is not just contempt as committed before the court in Roiro and in Kiambu. Contempt applies. Contempt of court cuts across the entire kit and caboodle of the judiciary. So there is a contempt against this court in presenting this accused person before you to stand trial over a matter that the prosecution chooses. We shall not go to the High Court. We shall instead take people to Kahawa. You know, I had some objections to arrogance. Arrogance does not come worse than this. That you are required by law to go to the High Court, you choose not to go to the High Court, and you decide we are heading to Kahawa. Why? Because it is an anti-terrorism court. We shall get back to that. It is still a court in Kenya, my lord. Your Honor. Your Honor, the second part of these orders from Kahawa were this. The prosecution was beseeching those courts to complete investigations. That's why they needed it. And the rulings were based on the fact that the prosecution failed to produce the evidence as required by the law. Is it 24A? 24A? That is 6A. Under 36A of the CPC. That is the legal facts as far as this matter is concerned. This is Friday. You had sought for 21 days to complete investigations over those very same facts. So that, Your Honor, and here I'm speaking about abuse of court process and abuse of power. It is obvious that And the law is, as we had submitted in Kiambu, that before a person can be lawfully prosecuted and take a plea, there must be a certain threshold of evidence that must be reached. The position in affidavit of the prosecution that is the subject matter of the ruling of 4th of July is that we do not have that evidence. And effectively, the courts were basically saying, let them be out. They gave conditions. You can to complete your investigations. Complete your investigations. Your Honor, they are nevertheless here because the prosecution and the state would hear none of that. They don't even have some respect for the High Court. Because the moment those rulings were that position, that if you wanted that position, that if you wanted, you are dissatisfied with what those magistrates said, you needed to go and convince a judge of the High Court that these are such dangerous people that your landed colleagues at Roiro and Kiambu got it wrong, and we must detain them. That has not happened. And it is the reason why we say the arrest and arraignment constitutes abuse of power. And they are before this court, constitute abuse of court process. This, Your Honor, I beseech you not to permit the prosecution and the Kenyan state to do this. That the Constitution means what the police and the DPP says it means. Your Honor, under our law, the Constitution is written, we know its meaning, and in terms of dispute, it means what the courts have interpreted. If the magistrates in Roiro and Kiambu got it wrong, get another interpretation on the meaning of our laws from the High Court. Anything short of that would turn this country into a police state. And, Your Honor, we cannot have... So that, Your Honor, to get into those other 5 points, now that you have that background, Your Honor, it is important that we point out that for purposes of Section 4 of the Constitution, Kenya is a constitutional democracy. That is Sections 4.2. And there is a constitutional democracy in which the values and principles referred to in Article 10 applies. One of them is to ensure that there is protection of law and the Bill of Rights. We submit that in a situation where a serious issues arise as to what is the correct conduct for a constitutional democracy, you cannot be able to say you have valid charges. In short, Your Honor, therefore, we are beseeching this court to make a finding that in a constitutional democracy, like it was done in Bennett versus Osfery in England, this kind of state conduct cannot be permitted. Second, Your Honor, is the issue of Article 38. Your Honor, the issue of Article 38 is important because that is the rights that were being exercised on the material day, the 25th of June, across the country. And it is important because my learned colleagues had said something about it, just for me to say that in the definition for purposes, I believe, of Section 4, there is a proviso that is made. Oh, yes. Yes, there is a proviso that is made that that is Section 2, actually. That with regard to that where a protest stoppage of work, that there is an attempt that is made by the Anti-Prevention of Terrorism Act to make sure that this law would not apply to certain kind of actions of a political nature. It is our submission that this proviso in Sections 2 of the Prevention of Terrorism Act was meant to ensure that in enforcing, in the implementation of the Prevention of Terrorism Act, the state would not cross the boundary. Because actions that and undoubtedly of a terroristic nature are punished separately from actions, any inconvenience, any destruction of property that happens in the course of pursuance of a political cause. That was the distinction that was sought to be made. And I believe, as I believe we've had this discussion previously with Senior Counsel Kalonzo Musyoka, the reason was simple. Why Parliament needed this proviso to be included. That we have it in fake democracies, starting with places like Uganda, where citizens engaging in legitimate political actions end up being charged with terrorist actions and in military courts. In this case, the closest they are getting is to come to a court that is supposed to deal with Al-Shabaab and other people dealing with dangerous things. Yona, this proviso is a logical basis for you, and I thank you for saying that you will take judicial notice of certain events, that the event of June 25, unless it can be categorized that throughout the country, that was a terrorist activity where there would be no basis to say some Kenyans who went to the streets on the same grounds committed terrorism. Everybody else did not commit terrorism. The law must be rational. Because the day it ceases to be rational, it becomes impunity. The related point, and which seeks to fortify Article 38, is Article 50 of the Constitution. This Article 50 of the Constitution, the ones that deals with the right to fair trial, issues to do with jurisdictions, a competent court, trial before a competent court. This is absolutely important for a very simple reason. When, for purposes of the trial, it must be done in an open court. The trial before an open court has got a very simple meaning. That an open court is a court that does not have extra security, that is easily accessible to the wananchi, and that deals with a matter of a civil nature or criminal nature, in the sense that these are law-abiding civilians of Kenya until they are found guilty. My Lord, under the Anti-Terrorism Act, the court that deals with terrorist acts in the Republic of Kenya is not a court that is truly speaking an open court. All of us, starting with myself, we were told to park my car about 400 meters from the courts. We couldn't get in, and we had to walk all the way from the gate. Why? Because there is no facilitation, the facilities of an open court that is provided in Kahawa. Because in Kahawa, we deal with terrorists. So that, Your Honor, if for a minute it were to be accepted that people who are pursuing a political cause within the meaning of Article 38 of the Constitutions will be tried in Kahawa, we shall not only make a mockery of our national security, we shall also end up weaponizing the law made for terrorists to deploy it against those that we think we disagree with politically. And that is where the issue of political persecution comes in. And, Your Honor, we urge the court not to go back that road of weaponization of the judiciary against sections of the Kenyan citizens with opinions that inconveniences the government of the day. We've been there before. It was a catastrophic time, and the reason why the 2010 Constitution exists. Your Honor, that point I make it with regard to two last issues that I'm about to make. Sections 42A of the CPC, Sections 42A of the Criminal Procedure Code, these sections, Your Honor, says it talks about the disclosure by the prosecution. 42A1 says, pursuant to Article 52J of the Constitution, the prosecution shall inform the accused person in advance of the evidence that the prosecution intends to rely on and ensure that the accused person has reasonable access to that evidence. 2 is the one that is most important. In the proceedings under the Prevention of Terrorism Act, the Narcotic Drugs and Psychotropic Substances Act, the Prevention of Organized Crimes Act, the Proceeds of Crime and Anti-Money Laundering, and Counter-Trafficking in Persons Act, the prosecution may, with leave of the court, not disclose certain evidence on which it intends to rely until immediately before the hearing. Then the other provision sets out. You know, why is this section important? This section is important for the simple reason that because terrorists are such dangerous people, that we've read, it's a CPC, sections 36A. CPC, section 36A. Just sorry, 42A, sorry. Yeah, we were dealing with 36A, the other side. 42A. Yona, what is it about this section? Yona, what these sections is based on is because those specified offenses are deemed to be of such a severity and so harmful to the public and to national security that despite Article 50 of the Constitution, the state is allowed to prosecute the case without availing all the evidence at the commencement of the trial. That is an absolutely important issue because one of the most important safeguards, you get the materials for your trial. So when you try a terrorist, you use a lower threshold. You can keep some of the evidence, you can suppress, which is not possible with the crimes that they were initially charged with. They were initially charged with. So that, Your Honor, the point that we are therefore making with regard to sections 42A is that if you agree that people pursuing a political cause will be charged under provisions of the law and before a court under which they will enjoy less protection, it would be a very, very dangerous thing to be done. The final point, Your Honor, is on the famous Githunguri versus Republic case. I believe this is a case, 1986, we all know it. I am a fan of listening to interviews by JSC when people are being invited to be for higher offices. Majority of judges cite this case as one of their favorite decisions. And I believe it is for a good reason. And what's the main point of Githunguri that I want to urge today? It was about abuse of power, abuse of court process. But more importantly, there is an important phrase that was made in the language of the famous Justice C.B. Madan, to the effect, Your Honor, that a good prosecution or a lawful prosecution is determined at the commencement on how it starts, not how it ends. We have submitted, this has started as terribly, as unlawfully as it is possible. I have heard from the prosecution when it was responding later on that, oh, we shall sanitize this, we shall give evidence, everybody will be satisfied, let them wait. Your Honor, in the case of Githunguri, the point was, what is unconstitutional in a demonstrable manner cannot be sanitized, cannot be constitutionalized. I urge the court, and I thank it for giving us time to ventilate that issue, to dismiss this, and to discharge specifically the accused person until they are lawfully presented before this court. Your Honor, we are most obliged. Thank you.
I wish to add 2 points to what my learned colleague has said. Constitutional question. Yeah? Your Honor, I wanted to address these issues together with what my learned has raised. The doctrinal application. It is implied in Article 160 clause 1, where this court is presumed to be independent and impartial. And Your Lordship, you derive your powers from the people of Kenya under Article 159.1 of the Constitution. So I want you to read Article 159.2e. It obligates you to apply for any demonstrator. Then you can now assign vindicated, Your Honor. And that's why they are all bound by Article 1 and Clause 2. The Constitution
they violate Article 24 and the other